Goedemiddag. Hierbij open ik het rondetafelgesprek Varend, ontgassen van de vaste commissie voor infrastructuur en waterstaat. Dit rondetafelgesprek bestaat uit de volgende blokken. Blok 1 juridisch, blok 2 privaat domein, blok 3 publiek domein. Nou ja, een rondetafelgesprek is ook een beetje naar aanleiding, nou een beetje is gewoon eigenlijk naar aanleiding van de artikel in de NRC waar nou ja, de twee gasten uit het eerste blok in stonden. Ja, met de sprekers is afgesproken dat in het eerste blokje ieder 3 minuten krijgt om kort toe te lichten wie zij zijn en wat hun hoofdboodschap is. Vervolgens krijgen de Kamerleden de gelegenheid om vragen te stellen. Ja, ik zit nu ook voor, maar ik was ook een van de opzetters van het rondetafelgesprek. Mevrouw Koerhuis ook van GroenLinks. Een andere die mede het rondetafelgesprek heeft opgezet is de heer Tjeerd de Groot. Ik begrijp dat die om 5:15 aansluit. De heer Van Raan van de Partij voor de Dieren. Die is hier nu niet, maar ik begrijp dat zijn medewerkers meekijken. Mevrouw Van der Plas van de Boer-Burgerbeweging had zich onder voorbehoud aangemeld. Afgemeld of niet?
Onder voorbehoud aangemeld.
Nou ja. Ja. En de heer Alkaya van de SP heeft zich helaas ziek gemeld. Dus de heer De Groot komt er zo nog bij om 5:15. En
extra vragen.
ja, de vragen genoeg. Ja, dan zou ik graag het woord willen geven aan mevrouw Arcuri en de heer Arol van de Erasmus Universiteit. Allereerst aan mevrouw Arcuri.
Thank you. Just for the sake of clarification, we were informed that we would have 10 minutes time to present, and it seems to me we have such time given that some members couldn't make it. Dear honourable members of the Parliament, we are grateful for this invitation and the opportunity it gives us to clarify a few points in relation to the question of whether regulating floating degassing is compatible with international law. Our report shows that the existing international legal framework relating to floating degassing does not prohibit the Netherlands from implementing domestic measures to regulate degassing on their inland waterways. Furthermore, we have concluded that in accordance with international human rights law and pertinent Dutch case law, the Netherlands may have an obligation to regulate degassing in order to safeguard the right to life and privacy and family life of its inhabitants. As you know, in response to our report, the Minister stated that regulating floating degassing is not feasible under international law. The Minister presented several arguments to support this position, namely the following. The Dutch state is restricted from acting due to Article 18 of the Vienna Convention on the Law of Treaties. Second, the 2017 CDNI amendments cannot be provisionally applied as it is not explicitly stated in the amendments. Third, the Dutch state is in compliance with its human rights obligation, having negotiated the 2017 CDNI amendments. And finally, he mentioned practical difficulties may arise in implementing the ban. In this presentation, we will briefly recall why the Netherlands has the right to regulate floating degassing and rebut each of these claims made by the Minister. At the outset, it is important to remember that the European Agreement concerning the international carriage of dangerous goods by inland waterways, also called EDNI, which was concluded in Geneva on 26 May 2000 and entered into force in 2008, establishes clear right to regulate of the member of the treaty. Here it is worth to bear in mind that Article 7237 of the annexed regulation reads, gas freeing of empty or unloaded cargo tanks is permitted under the conditions below, but only if it is not prohibited on the basis of international or domestic legal requirements. Moreover, Article 6 of ADN recognizes, and I quote, the sovereign right of states to regulate or prohibit the entry of dangerous goods into its territory for reasons other than safety during carriage. These rules unambiguously provide that states can establish domestic legal requirements prohibiting gas freeing of emptied, unloaded cargoes. These rights will only be reinforced by the 2017 CD&I amendments that establishes an obligation to adopt a ban floating degassing. The minister, however, argued that Article 18 of the Vienna Convention on the Law of Treaties would bar the Netherlands from acting. According to Article 18, when a state signs or ratifies, as in the case of the Netherlands, which has ratified the treaty, a treaty that has not yet come into force, and I quote, "The state is obliged to refrain from acts which would defeat the object and purpose of a treaty." The minister argues that the establishment of infrastructure for degassing, as mandated by Article 5 of the 2017 CD&I amendments, implies that a national ban on degassing without such infrastructure in place would be in violation of this norm. This reasoning is questionable for at least two reasons. First, Article 18 of the Vienna Convention talks of object and purpose of a treaty. In this respect, we should note that one of the main purposes of the 2017 CD&I amendments is the protection of the environment. It follows that if Article 18 of the Vienna Convention is to be invoked at all, it may be to argue the opposite of what the minister argues. In 2017, amendments were made to the CD&I in order to achieve the goal of protecting the environment by prohibiting floating degassing. A domestic regulation aimed at protecting the environment could not violate the object and purpose of the 2017 CD&I amendments, which were enacted to achieve the same goal. In fact, actively delaying the adoption of measures which could protect the environment and public health by regulating floating degassing can be seen as defeating the purpose of the treaty and violate Article 18. So the delay that is being adopted, the omission, could be seen as a violation. We don't argue that in the report, but it could be seen. Second, even if we would want to focus on the specific provision which the minister mentions, we would reach a different conclusion. The Article 5 of the 2017 amendments reads, "The contracting state shall undertake to set up or have set up the infrastructure, etc." This is a positive obligation, meaning that the state is required to take action. Nothing in the treaty prevents the Dutch state from beginning to establish the necessary infrastructure without delay. So let us now move to the other question that the minister mentions of provisional application, and I pass the word to my colleague Abdurrahman Erol. Thank you.
So, in our report, we have demonstrated that states have the right to regulate beyond safety during navigation, including protecting the environment. And exercising this right by regulating floating degassing at the domestic level is different than the provisional application of the CD&I amendments. Provisionally applying a treaty means undertaking international obligations. Domestic measures compatible with the 2017 amendments would not amount to a provisional application of the treaty. As with such measures, the Netherlands would not undertake an international obligation, but simply exercise its right to regulate established by AVN. A state's efforts to ensure that the safety of its people and environment by keeping danger out of its territory cannot be equated with imposing obligations upon other states. This emanates not just from its sovereignty, but also its obligations towards its citizens. And this brings us to our next point. The minister argues that the Dutch state is in compliance with its human rights obligations, having negotiated the CD&I amendments. While it is commendable that the Netherlands has taken an active role towards the adoption of the CD&I amendments, it is unlikely that the mere act of negotiating and ratifying a convention will satisfy the duty of care in this case. Similarly, it's hard to see how the fact that an implementing regulation is ready but not implemented can be equated with the respect of human rights obligations. Given the stalling situation around floating degassing and the fact that international treaties have been used as an argument not to act, It is questionable whether, in this case, the ratification and the existence of an implementing regulation could be considered as sufficient conditions to fulfill human rights obligations. The human rights of the Dutch people remain unfulfilled until they continue to be exposed to the toxic gases emitted through floating degassing. And finally, on the question of the practical difficulties on establishing a ban, it is not within the scope of our report to address this question. However, as international lawyers, we want to emphasize that it is the responsibility of the Dutch state to find a solution to the problem of floating degassing. And given the negotiations on the amendment were initiated in 2012 and concluded in 2017, and that the expectation was that by 2020 all members should have ratified, it may have been reasonable to start building the infrastructure years ago. When the amendments will enter into force, the Netherlands is obliged to apply it. And this is because a part of a treaty may not invoke the provisions of its internal law as justification for its failure to perform an obligation arising under such treaty. So to conclude, under the current international legal framework, the Netherlands has a right to regulate to protect the environment and public health of its residents. Moreover, under international human rights law, the Netherlands is most likely under an obligation to regulate floating degassing and protect its citizens. And the mere negotiations of a treaty cannot be equated to performing this obligation. Finally, in light of the fact that CDNI may enter into force soon, the Dutch government should create the conditions for implementing the ban, as it cannot use domestic law as a reason to not respect its obligations under the 2017 amendments. So many thanks for listening, and now we are happy to hear your questions. Thank you.
Ja, dank u wel. Ja, interessant, kan ik wel zeggen. Ja, hoe zullen we dat doen met de vragen? Ik heb in ieder geval zelf een vraag, maar ik zal beginnen met jullie. Zullen we eerst mevrouw Kreuger een vraag laten stellen? Beantwoording. En als er daarna nog een vervolgvraag op is, dat mevrouw Kreuger die meteen kan stellen. En dan gaan we verder. Dank u wel.
Dat klinkt helemaal goed, voorzitter. En ik heb 2 vragen. Dus ik zal eerst de eerste stellen en daarna de vervolgvraag. Mijn eerste vraag is eigenlijk dat ik de onderzoekers, dat ik het u nog scherper bijna hoor zeggen. Namelijk dat het niet alleen een mogelijkheid is om nationaal te reguleren, maar dat het zelfs eigenlijk een verplichting kan zijn onder internationale mensenrechtenverdragen. Nou hebben wij in Nederland helaas al een aantal rechtszaken gehad met betrekking tot milieu, klimaat, stikstof. En hoor ik dan eigenlijk ook hier bijna dat als Nederland niet zou reguleren, dat we dan kwetsbaar zouden zijn voor dit soort mogelijke rechtszaken.
The short answer is yes. In fact, in our report, we discussed the Urgenda case, which lends itself to a good analogy of the situation of what is at stake with floating degassing. So, yes, but hopefully the government will act and there would not be a rechtszaak, but technically this could be possible.
Ja, als Kamer kunnen we ook zelf acteren. Maar, uw vervolgvraag?
Ja, en dat is eigenlijk dan over de argumentatie van de minister. Want die zegt eigenlijk, nou ja, wat ook net geschetst werd, hè, dat de minister het uitgangspunt hanteert dat een maatregel in strijd is met het doel en het voorwerp van het verdrag en daarom niet mogelijk is. Dus artikel 18 van het verdrag van Wenen. En mijn vraag is eigenlijk dat de belangrijkste argumentatielijn van u als onderzoekers is eigenlijk niet dat het juist wel binnen het verdrag van Wenen zou moeten gelden, dat je het juist zou moeten doen, het reguleren.
All right, here there are, it's a bit more complicated because the ministers say we cannot do because of Article 18. So we counter this argumentation. We say you can do because the way you are reading Article 18 is probably not correct. And so we maintain our position that you can act. There is an argument which we did not develop in the report, but that one could think of, if even exactly the opposite may apply. We don't go that far, but it could even be argued that Article 18 could constitute an interim obligation to act. And why this is the case? This is because we have to look at the object and purpose. So if by not acting, so what is the object and purpose? We know that it is protection of environment and public health of people. By not acting, it means that floating the gases is being continued and people are exposed to the harm. So the question is, can this mean that the very object and purpose is being defeated? And one answer is yes, it could mean that. If that is what it means, then one could use Article 18 to argue exactly the opposite of what the minister argues, that is, the Netherlands may even be obliged to act under Article 18. We're not claiming this is, this could be, we have to engage more with this object and purpose, but prima facie, on its face, actually, it can be argued to say the opposite. Certainly, it cannot be argued, we think, what the minister maintains, that Article 18 impedes the Netherlands to act because acting would be a violation under Article 18. This, it's really something we cannot understand what the reasoning is behind. First of all, because the minister mentions one specific article, which it's questionable whether the very specific article is coincide with the object and purpose first. Second, the specific article is an obligation to do something, so it's not an obligation not to do something. So it's very cryptic for us what they mean when they use Article 18 in combination with Article 5 of the CDNI. To us, it's not understandable. And in the past, we sought a conversation with the minister, but our questions were not answered. So we just cannot understand what is the logic. In our analysis, Article 18 does not constitute any obstacle to act. If something, it could even mean that the Dutch government may have already a legal obligation under international law to act.
De heer Krul van het CDA.
Ja, één vraag die eigenlijk ook weer een beetje voortborduurt op de eerste vraag van mijn collega hier. Het korte antwoord was ja. Op de vraag of het gezien kan worden, het vertragen gezien kan worden als een violation, als het ware. Wat zouden dan daarvan de implicaties zijn voor de Nederlandse staat? Wat zijn de mogelijke gevolgen in het scenario waarin het inderdaad blijkt dat het vertragen alleen al van het uitvoeren of het tegengaan van varend ontgassen een inbreuk zou kunnen zijn?
Even, als u de microfoon aan wil doen.
Yes, I'm not sure I completely understood the question. So the question is what would be the implications of violating the Human Rights Convention, or it was referred to all the conventions? That was something I didn't understand.
Er werd gezegd, the delay could be seen as a violation, but it wasn't the scope of our research, but we're saying it now. That's what you said in the first bit. What would be the implications of that?
Yes, that's being in violation of international law. So what would be the implication? Could there be a dispute? In general, the Netherlands is a state that praises itself for wanting to be in line with international law, in compliance. So the implication would be that they would be violating international law with this very omission. It would be a violation of international law. I mean, I would not want to speculate on the practical implication, whether it would be that the same question could be asked of what, if the Netherlands would act, what would be internationally the action that can be initiated by other states. I don't think that's very relevant because the main consideration here, as far as we understood from reading all the statement of various ministers, is that the goal is to be in compliance with international law. So we are saying You are in compliance if you regulate. That's no question about that. You may even be in violation of international law if you don't.
Ja, ik heb, mijn vraag zou zijn over wat de stand van zaken is, hoe andere landen tegen de discussie hier aankijken. Hoe kijken, als u het weet, hoe kijken België, Duitsland, Frankrijk, Luxemburg en Zwitserland aan tegen deze discussie die wij hier voeren en tegen het standpunt van de minister?
We haven't looked into that at all, so we cannot answer this. This question. Is there a particular reason why you would want to know?
Hoe is het verbod op varend ontgassen geregeld in die andere landen dan?
So for
in
example,
relatie tot het verdrag?
Well, what I think you all know is that it's less relevant for countries like Switzerland and France for the simple fact of how the rivers cross these countries. And in the case of Germany, now it's been amply discussed in the media, there is a de facto much broader ban than in the Netherlands. And in Belgium is de facto the same, even if legally it's more complicated. So in Germany, we know that there is a legal ban that goes beyond what is regulated in the Netherlands. In Belgium is formally the same, but de facto different because of the fact that the harbors are very close to the border, and that means that as far as we understand, and this is not as international lawyers, of course, but just reading the dossier, that de facto then ships come to the gas in the Netherlands because of a combination of a legal regime in Germany and the very geography of Belgium and Germany. And for the others too, you know better than me, I think, what's the state of affairs. Ja.
Mevrouw Koerhuis, voor een derde vraag.
Ja, dankjewel. Dank u, voorzitter. De minister geeft nog een argument in zijn brief aan ons als Kamer. En dat is eigenlijk dat hij zegt van de voorlopige toepassing van het ontgassingsverbod door een verdragsstaat in de wijziging van de scheepsafvalstoffenverdrag zelf zijn geregeld. En daar is nu geen sprake van. En dat is ook een aanwijzing dat een vooruitlopende regeling onder dit verdrag niet mogelijk is. Hoe kijkt u naar dit argument?
I understand correctly, you are talking of the provisional application, right? So this is also something we touched upon. What we are arguing is that this would be unilateral measures of a state. Now, the provisional application is also regulated by the Vienna Convention of the Law of Treaties under Article 25. What is specific about provisional application is that you undertake an international obligations. Now, by regulating having a domestic law, you're not undertaking an international obligations. That would not be the goal. So it's not provisional application in that respect. And there is, if we want to go more into the technical, there is choice, for example, in some commentaries on Article 25 that shows that unilateral acts of states cannot be equated to provisional application. So the provisional application is specific of an international obligations. If the Dutch state says, okay, we want to start to apply the treaty, and therefore we are implementing an obligation that we have. But when you adopt domestic regulation, which you can adopt, that doesn't amount to provisional application as such. Incidentally, but that's incidentally, of course, if the Netherlands wanted to go for provisional application in 2017, it could have done so, because the minister referred to the first paragraph of the Article 25 that says it's not in the treaty, but there is a second paragraph that you can just, by a unilateral declaration in this case, try to engage, and then the other states have to agree. So in 2017, when the treaty was signed, they could have gone for this option. They didn't. That's a choice, but what we are arguing is that these domestic measures are not international obligations as such, so they would not constitute a case of provisional application of the treaty.
De heer Krul van het CDA.
Permitteer ik me als nieuw lid er maar 1 of 2 lekenvragen. Ook voor mijn eigen beeldvorming. Nogmaals, ik hoor gezegd, als het te lang duurt, als er te veel delay is, dan zou dat ook nog eens juridische consequenties kunnen hebben. Maar ik lees ook uit de brief van de minister dat hij aangeeft, ja, maar wij hebben juist een proactieve rol gepakt. We hebben ook het initiatief gepakt voor dat internationaal ontgassingsverbod. En het is misschien zelfs wel onevenredig om een nationaal verbod in te voeren, omdat we dan de tankervaart stilleggen. En zeggen ze ook nog eens, het zijn de provincies die verantwoordelijk zijn voor het verlenen van de vergunningen voor ontgassingsinstallaties. Alles bij elkaar opgeteld zouden we niet gewoon kunnen zeggen dat wij in onze macht doen wat we kunnen doen om het te regelen. En daarom het woord vertragen of delay of niet voldoen aan, ja, in die zin de inspanningsplicht of de verplichting juist wel voldoende belicht wordt vanuit de overheid gezien. Kan jullie daarop reflecteren of is dat echt niet aan de orde?
Yes, thanks for the question. I think this raised 2 issues. One, and correct me if I understand your question wrongly, but one of the issues you raised is, they say, well, there is a question of competence in the Netherlands, who is competent, etc. Now, this is something that when the treaty will enter into force, the Netherlands cannot choose to say we cannot act because it will have an obligation. And domestic law, practical difficulties, they are not arguments that you can use under international law. So they have argued, as far as we could follow, that this year Switzerland will ratify and this will enter into force. If this is the case, it is urgent that this issue is resolved because this is not an argument under international law. Besides, this treaty has been negotiated years ago. So 2017, the negotiations ended. So I think there is 2 prongs on your question. One is this one, that the Netherlands has to solve the problem because it will have an international obligation. And the other is the Netherlands as being a leader in the negotiation of the 2017 amendments. Is that not sufficient proof of their compliance with human rights? So we applaud the Dutch government for having been an active, taking an active role in these negotiations. However, these negotiations and the successful conclusions of the negotiations cannot in themselves correspond to fulfilling an obligation to meet the human rights obligations that they have. Partly because you could say, well, and what if Switzerland never ratifies? Or, you know, it could even, if one would take that as a doctrine, it could be used as a way to hollow out the core of human rights provision, that you go the formalistic way, we have concluded. So when it comes to human rights, you really have to act. You look at the effect of the action. And in that sense, we do not find persuasive the argument of the minister that says, well, we have been leaders. We do appreciate, we think this is politically to be appreciated, but legally, that's not a sufficient condition to fulfill a human rights obligation. And if we think of the time that elapsed from when the treaty was concluded, that even adds an extra argument of why action might be needed now for this reason.
Ja, nog een
nog één andere vraag. Iets ander onderwerp. En ik denk dat